Are your kids aiming for top Ivy League colleges? Are your kids aiming for top 1% scores in SAT or ACT? What is the biggest hurdle? English. To have a strong foundation in English, Test Prep Pundits presents long-term SAT, ACT English program with robust curriculum and experienced teachers. For grades 6 through 10, just $80 a month. Contact us, info@testpreppundits.com or call us 844-383-7844.
ఈ పండగ సీజన్ లో మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి గిఫ్ట్ ఆఫ్ గోల్డ్ తో ఇంట్లో సంతోషాలు సమృద్ధిగా నింపండి. బంగారు వజ్రాల ఆభరణాలపై బంగారు నాణ్యాలు గ్యారంటీగా పొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. చక్కటి డిజైన్లన్నీ చక్కటి బహుమతులతో సహా చక్కటి ధరలకి ఎంజాయ్ చేయండి. అపరిమితమైన సంతోషాలని మీ ఇంటికి తీసుకువెళ్ళండి. మలబార్ గోల్డ్ అండ్ డైమండ్స్, సెలబ్రేట్ ద బ్యూటీ ఆఫ్ లైఫ్.
సిలికాన్ ఆంధ్ర మనబడి అమెరికాలో ACS వాస్క్ గుర్తింపు పొందిన ఏకైక తెలుగు విద్యాలయం. మీ పిల్లలను 2021-2022 తరగతులలో చేర్పించండి. తరగతుల నమోదు ప్రారంభమైనది. సెప్టెంబర్ 11, 2021 నుండి తరగతులు ప్రారంభం. మనబడిలో చేర్పిద్దాం, తెలుగు భాష నేర్పిద్దాం. మరిన్ని వివరాలకు సంప్రదించండి manabadi.siliconandhra.org, info@manabadi.siliconandhra.org, 1844-626-BUDDY.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour, or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info@testpreppundits. Call at 844-383-7844.
తెలంగాణ అమెరికా తెలుగు సంఘం TTA ఆధ్వర్యంలో న్యూ జెర్సీలోని కన్వెన్షన్ అండ్ ఎక్స్పో సెంటర్లో మే 27, 28, 29, 2022 ఈ 3 రోజులు మెగా కన్వెన్షన్ నిర్వహించనున్నారు. ప్రముఖ వ్యాఖ్యాత సుమా కనకాలతో పాటు మరెందరో సినీ రాజకీయ ప్రముఖులు విచ్చేయనున్నారు. అంతేకాదు ప్రముఖ గాయని గాయకులతో SPBకి ఘన నివాళి, కప్రిసియో బ్యాండ్ మరియు వైవిధ్యభరితమైన ప్రత్యేక కార్యక్రమాలు ఆహుతులను అలరించనున్నాయి. ఆటలు పాటలతో సినీ తారలు, బుల్లితెర నటీనటులు, జానపద కళాకారులు అందరికీ ఇదే మా సాదర ఆహ్వానం. For more details, please visit www.tdaconvention.org.
A new wave in the test prep. Test prep pundits offer SAT, PSAT, ACT just for $499, with powerful teachers, with top 1 percentile tutors, and powered by stellar digital curriculum. Contact us at info@testpreppundits.com or call at 844-383-7844.
If tax rate is your issue, we're probably not your state.
Tone deaf and out of touch. Phil Murphy just doesn't get it. I'm Jack 𝗔𝗏𝗏𝐿𝐴. It's not just taxes where he's failed us. Phil Murphy ignored the warnings and sent COVID patients into nursing homes. 8,000 seniors and veterans died. He tried to ban cops from notifying parents when kids are caught with drugs or alcohol. Who does that? Had enough? New Jersey, it doesn't have to be this way. We can do better. And when I'm governor, we will.
Fine diamond jewelry is now one click away. Maya Fine Jewels, a family legacy, manufacturing their own jewelry since 1975. Shop online for lab-certified diamond jewelry at Indian prices. Visit your trusted family jeweler, Maya Fine Jewels, at 1315 Oak Tree Road, Islin, New Jersey. Shop online at mayafinejewels.com.
Telugu ప్రేక్షకులందరికీ hello and welcome back to yet another fabulous episode of our talk show with experts. మనతో ఉన్నారు మన expert రాహుల్ రెడ్డి గారు. రాహుల్ గారు, thank you so much for being on the show అండి. Rahul garu, are you on with us, Andy? Okay. Hi. Sorry, Andy. I think there was some technical issue that was going on. For our viewers, this program has been brought to you by Test Prep Pundits. They help you achieve the best for your kids on SAT and ACT Test Sunday. Test Prep Pundits is on a roll. 28% of their students got top 1% scores in the October 2nd test that was conducted. 70% of the test takers got 95 and above percentile. It's amazing and incredible. So what are you waiting for? Contact the Test Prep Pundits. Thanks to their teachers, students, and parents for all their hard work. I think they deserve what they have. So, get your kids in there because they're the best for SAT and ACT tests. The program has also been supported by movers.com and Malabar Jewelers. All right. Now getting on to our topic for the day. US senators request USCIS not to waste employment green card. Rahul Garu, I know we've been talking around, this whole thing about the green cards, whether it's wasted, not wasted, what's happening. We're writing tons of letters. You're posting like templates that they can use. So what exactly is happening, Andy? Can you elaborate on that for us?
Well, it's definitely helped writing letters. A lot of people think so that it didn't help. We can see the letters from Senator Cornyn, Senator Cornyn, Senator Collins, Senator Tells, Senator Rand Paul. We have seen that they have responded to it. They are asking many questions so that they don't waste the green cards that we got, the 150,000 green cards that we got. If you look into Nithya Garu, the first 3 quarters of last year, starting from October 1st of 2020, they only used up approximately around 73,000 or 75,000 green cards. So in the entire first 3 quarters.
Okay.
In the last quarter alone, they have given 100,000 green cards, actually 105,000 green cards in the last quarter.
Right.
So what they have done in the first 3 quarters have done much more than in the 4th quarter, though. Definitely writing letters to the congressman, writing letter to the ombudsman, writing letters to all these things did help. The USCIS did respond with Twitter. They have given very much preference to the employment base. And also now, when we are writing the letters to the congressman, it definitely helped. If they go in the same pace, though, definitely we will be able to utilize the 290,000 green cards. Had we done this activity starting in October of 2020, though, yeah, definitely it would have been a much better help. We would have used up the 80,000 green cards also that were unnecessarily wasted. The priority date would have moved much further than what they actually have moved, have we done the effort, though. It could be that we didn't calculate it properly. We have been told by the administration that, yes, I expect the employment-based green cards, all of them to be used. They kept on telling. And when it came to May or June, they started flipping. They expected 100,000 plus to be wasted, though. But anyway, what I want to keep the pressure on the Congress. I want to keep the pressure on the Ombudsman. Keep writing letters. The drafts were being provided, the link. Especially we want legislation to be included in the employment base. It also helped that we identify our problems because we are waiting for the green card so that senators and congressmen are aware of it.
Okay. Thank you so much, Rahul Garu. And I know there's a lot of people waiting. So just so that the callers know, I'm going to be announcing out the last 4 digits of your phone number. So please be on the lookout for that. So when I tell you you'll be ready for you, please be on the lookout for the last 4 digits of your phone number. Okay. All right. On to our callers, Andy. Let's take our first caller for the day. Rahul Garu, there have been tons of questions also that have been coming in. I think one question we have here from Vamshi Krishna, he says, are you seeing any pattern of H4 EAD getting approved, like applying H1, H4 and H4 EAD in regular and upgrading to premium later? Is that something that's been helping?
No, it's not been helping. We as previous to 2019, as you already know, that when we file H1, H4 and EAD, it used to get approved together, though. Okay. After introducing the H4 biometrics, though, Definitely, things started taking long time. So we adopted a strategy at that point of time to wait until the biometrics happen and then file the premium processing. That did not help either. Obviously, we sued USCIS almost 800 times on the H4 EAD. We won most of the time, and then we started losing the cases because they kept on, haggling around the jurisdiction and other issues. So we sued them we sued USCIS on a class action suit, and we are able to get the biometrics out. The suit is still there. We want USCIS to adjudicate the 485, EAD within 1 month after we file the application. That's one thing that we want them to do. We also want them to include the extension provision. What I'm telling Nithya Garu is that when you file an extension for a adjustment of status EAD, you can, when you file a STEM extension though, you can work while the application is pending for a period of 6 months. We also want USCIS to do that thing, so that litigation is also pending. So hopefully, that will come soon. In the meantime, we have no method to expedite the H4 EAD. You can try your luck with congressmen. 98% of the time not working, ombudsman not working, but we are doing our efforts as lawyers to do the H4 EAD much faster. But it may take a little bit more time, and the courts will take time to get the things working out for us.
Gotcha. Thank you so much for that, Rahul Garu. Let's take our caller, Andy. Last 4 digits again of your phone number. It is 6640, Andy. Last 4 digits of your phone number is 6640. We're ready for you now.
Hello, ma'am. Can you hear me?
Yes, sir. We can hear you. Please go ahead.
Yes, sir.
Sir, okay, now we can hear you.
Hi, sir. So actually, I have 2 questions, but one, my question is, like, I have and my wife, both of them, like, independent green card process with our different employers, and my priority date is August 2011, and my wife was later on October 2012. So last year, in October, we decided to file under my wife's under petition, and we filed her EB3, straight EB3, and we also filed 140, and everything, 140 got approved. And as you know, right now, she was a primary, I was a dependent, and now her date retrogress. So her priority date is October 2012, and now it's retrogress to January 2012. Now my question is, now my EB2 priority date is August 2011, which is current. Now, is it something, can I link my EB2 I-140?
No, you cannot link, you should not link your I-140 to the adjustment of status. The reason is that you must be eligible for it all along. For example, if she wants to switch to EB2, she can, because she had an EB2 and now she has an EB3 approval though. So, but in your case, in October, when you filed the 485, based on the EB2, you are not eligible for it. Are you still maintaining the non-immigrant visa status H1B for both of you guys?
Yes. We are both.
The best strategy for you is to file another 485 application on you. That is the best way to do it.
Okay, so that's what I thought, and that's what I based on the videos, that's what I suggested my company's attorney, and pretty much they are saying, no, since you have already filed with your wife, you cannot have a second 485
tell them
pending.
in October, November, December, January, February, March, April, May, June, July, August, September, October, June, July, August, September, I don't know about October, but in all these months, your I-140 was not eligible to file a 485 application. So you don't have a basis. That's my opinion, but it's up to you whom you want to trust.
No, I understand. And that's what, I mean, it's just like, you can't really like push them. And I was like, hey, can I file independent 485 as a separate one? And basically we would have a both pending 485. And they're saying, no, you can't have a second one pending. You already have one pending, so you can't file the second one. And what they are willing to do, they're saying, we can link your EB2 140 approval.
I would not.
Pending, and
I would not. We do file second 485s many times. We don't have any problem with it.
So now, same question I wanted to ask you what you just said. Since I was not eligible last year in October, my EB2 was not eligible, my 140 wasn't eligible. What about the people who downgraded from EB3 to EB2, EB2 to EB3?
Good question.
They were also not qualified last year in October.
Good question.
Now
Good question.
Yeah.
For them, they can interfile. They can interfile because remember, they were eligible for the 485 based on the EB3 though. Okay?
Correct.
But in your case, you are not eligible. You never filed an I-140. So for them, either they can interfile or they can do the refiling if they maintain the non-immigrant status. In your case, you are not eligible. You never filed an I-140.
Yeah. No, but my I-140 was already approved. I never filed 485. I-140
but you were not eligible to file the 485 application at that time. There is no basis for you.
Correct.
Your wife is different. That's a different application. You do not have independent basis. Okay.
If I had like downgraded myself to EB2 to EB3, then it was a different story, and then I would have maybe even if I had to like now go back to EB2.
You're absolutely right. You're absolutely right.
Yeah. No. Now, do I have other options? Like, especially if my company's attorney, if they are not willing to file, can I, for example, can I come to your firm and can you do it? Like, can your
you can go to any other lawyer, but the company needs to still sign the 485J supplement. If the company is willing to sign the 485J supplement, you can go to any other lawyer. But if they are not willing to sign the 485J supplement by yourself, you cannot file the 485. Yeah. Let's go to the next.
Okay, so basically my company has to agree with that, right? Even my wife's attorney, they can also not do it, right?
Anybody can file, but your company has to sign the 485J supplement. Let's go to the next person.
Okay.
Yeah.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. And in the meantime, Rahul, we have a question for you. Let's just finish up this question really quick. Says, this is from Srini Rao, and he says, filed I-485 under EB3 from company A. The dates retrogressed. I also have an EB2 from a different company. Is it better to interfile EB2 I-140 or a fresh 485 with this other company B?
It's a very complex issue with regards to whether you should be interfiling or you should be filing a fresh application. In fact, I made a 15 minutes video. It's there on the YouTube. It's all explains about it.
Okay.
The advantages of interfiling is definitely, in his case, he has both EB3 and EB2. Both of them available in October of 2020, though. So definitely, he can do interfiling, unlike the other caller. Okay. So if you do interfiling, the only problem is the USCIS is taking a long time to get the application in there. Sometimes it may take almost like 3 to 5 years to get inside. It's not, interfiling is not very similar to that of the medical thing. All they do with medical is that they stick it in the file. There is nothing there. No entries need to be changed.
Right.
If you do interfiling by EB2, they have to do a lot of things different in there. And some of the officers don't know how to do it, and they will take time. And that is the main cause. Sometimes people choose to go for refiling. If you do refiling, there are also some disadvantages. Definitely monetarily, you have to pay lawyer's fees again, legal fees again. That's a disadvantage of it. But there is a good chance that if you refile the application, you can get the application process much faster.
Okay. Thank you, Rahul.
And if you interfile, though, there is a still chance that if you're stuck with the Texas Service Center, you're still stuck with the Texas Service Center. If you're refiling, since your I-140 is already approved, there is a chance, there's a good chance you will end up with the National Benefit Center, which is very fast compared to in adjudicating the 485. And it's not a guarantee, but there's a good chance you'll end up in National Benefit Center.
Yeah. All right. Thank you for that, Rahul. Let's take our next caller. Caller with last four numbers 1641. We're ready for you now.
Hi, Nitya. Can you hear me?
Yes, sir, we can hear you. Please go ahead.
Yeah. Hi, Nitya and Rahul. Hope you are doing well. Rahul, I'm calling. This is for the second time. I actually called when you were in Cancun on the beach.
Thank you.
So I'm calling the second time. So my case, I just wanted to elaborate on that. So I filed for future employment, downgraded EB3, and I got my GC.
Sounds good.
And you have told very clearly that once you get the GC, you can flip the burger, do whatever you want. But
Microsoft CEO,
but interestingly, I was reading like a Murthy law firm blog where they have posted that there is a chance that your citizenship can be denied.
So we need to check what are the probabilities what they are speaking about. How many people have you ever noticed their green card getting revoked? How many people have whoever got the naturalization? When we say when lawyers say there is a chance, it could be like this, right? Is there a chance you might get a lottery? I mean, of a $231 million. Even under the circumstances, so I can't even imagine though that if they question, will they ever revoke it? I don't think so. They have an authority to revoke it. Can they question it? Maybe one in a half a billion times they can question it. Why you did not work for the company? You can always say that at the time of filing the 485, I had the intention of working. At the time of getting the green card, I had the intention of working. But I changed after listening to Rahul on the Cancun beach. I changed my opinion. That's it. You don't have to worry about it. It's the intention until you get the green card. It is not after that you can change your mind.
Got it. Rahul, what is the risk for an employer? So what is the risk for this?
No risk.
For the employer?
Employer has no risk at all. I mean, you are leaving the company. The employer still wants you. There is no risk at all. Absolutely none. Everything is good with the employer. Just like the way employees can change the mind too, employers can also change their mind. They thought that you will join, but then maybe the technology is improved. Maybe they don't like that some of the activities you do. They can change their mind. Absolutely no risk for the employers, no risk for the employees. I have never seen, I've been practicing for 25 years, never seen a single green card revoked because the person did not work for the company after they obtained the green card. Even for the people who got the green card for the future employer, that means they never even worked for that company. The contention is that there must be a genuine job opportunity that you intend to join. That's all. And there is a memo from USCIS that clearly states that a 485 cannot be denied based on the sole basis that the employee has never worked for the company. Now I'm speaking about the 485 denial. I'm not speaking about for after getting green card revocation. It's a very heavy process. It requires USCIS to take a lot of different actions. I have never seen it. So if somebody has seen it, that's up to them. I've never seen it. Okay, thank you.
Thank you, sir. Let's take our next caller.
Thank you.
Here's an interesting question. Wait 1 second. So there's a viewer called Sa. His name is Sa. His or her name is Sa. Says, what is the significance of the I-94 validity? If we travel in advance parole, what is our status if the I-94 date expires? I heard I-94 is given 1 year, even though EAD or advanced parole is valid for 2 years.
Good question. Question of the day. Now, I-94 validity has very serious consequences 999 times out of 1,000, 999 times out of 1,000 times. So, everybody need to check their I-94. If it is expiring, you better notify your lawyer. You better take care of it. Only in the case of advanced parole, that too employment-based. And if you are coming on H1, H4, okay, only if you're coming on H1, H4. And if you're coming on L1 or L2, these are the only 4 non-immigrant visa. I'm sorry, let me take it. If you are coming on advanced parole, let me take back the, there's no H1, H4. If you're coming on advanced parole for the 485 application for the employment-based, even if the expiry date is there, you can ignore the expiration date. It's applicable if you're coming on H4, L1, or to a lot of different non-immigrant visas But when it comes to the employment-based immigration, you're coming in advance parole. If the advance parole expires, you are still in legal status.
So the I-94, is that of any consequence in such a case, sir?
No. So let's say, for example, the gentleman came on advance parole in October of 2021, and the I-94 says that the I-94 says that it's expiring in October of 2020 on advance parole.
Yes.
He can ignore it. He can stay beyond October of 2022. Since it is an advance parole, employment-based I-94, he can stay beyond that period of time.
Okay. All right.
Sorry about the confusion about the H4 and L1s, but advance parole, you can ignore it. Thank you for getting the clarification clearly, Nitya garu.
Thank you, sir. Let's take our next caller, Andy. Caller with 9121 as their last 4 digits. Caller with 9121 as their last 4 digits. We're ready for you now. Hello? Caller with last 4 digits 9121. Okay, let's check out this other question also, Rahul garu. This is from Me. It says filed I-485 under EB3 downgrade, got my GC, but my dependent's case is still pending. Priority date is April 2012, getting retrogressed in November. Can I sponsor her in the family category now?
If they are maintaining the non-immigrant visas, not the H4 because they don't have H4s anymore. If they are maintaining the non-immigrant visa status though, yes, you can file the 485 application. If they are not maintaining the non-immigrant status though, if they are maintaining the non-immigrant status, you can file a 485 adjustment of status. But if they are not maintaining the non-immigrant status though, you cannot file a 485 though. They have to. You can file the council processing. That's one thing that you can do. The other thing that you can do is that you may do interfiling of I-130. That's an option too.
Okay.
Although interfiling here takes a lot of time and may take a lot of time, you may not have much better options here because once they don't maintain the non-immigrant status, that means that you got the green card, you are an H1, and your spouse is an H4. They are no longer an H4. Since they are no longer an H4, you cannot file a fresh 485 application though.
Gotcha.
But you can file an I-130, get an I-130 approval, and then interfile with this 485 application.
Okay. All right. Thank you, Rahul garu. Let's take our next caller, Andy. Caller with phone number ending in 3173. We're ready for you now. Caller with phone number ending in 3173. We're ready for you now. Please press *6 Andy to unmute your line.
Hey, hello guys. Rahul and Nitya, can you guys hear me?
Yeah, we can hear you, sir.
Yes.
Go ahead.
Hey, good afternoon. So my name is 𝗓𝗏. I called you last week, I think, or a couple of weeks ago. An EB3 rest of the world applicant under cross-chargeability. I applied last year in end of October. So I have a question. Most of the colleagues that I applied with and, some of the folks that I applied, that have applied after me have already received their green card. So, with that concern, I messaged Emma last week and asking about whether my case has been considered under cross-chargeability or whether they've set my case aside because my priority date is not current. And Emma came back. I think they got confused and they said that they've scheduled a call with the Tier 2 officer to resolve this issue. I didn't know that there was an issue to begin with, but they've already said that they've scheduled a call with a Tier 2 officer and they'll call me back. So what does this really mean, Rahul? Is this going to be an adjudicating officer that's going to call me, or?
First is, can you explain cross-chargeability? If you explain, people will understand much better. I know the cross-chargeability, but I just want you to explain.
Okay, so
how were you eligible for cross-chargeability? Can you let us know?
Okay, so in my case, I'm an EB3 applicant, and my country of birth is India, and I'm married to my spouse, and she's my dependent, and she's born in Canada. So Since she was born in a country that has a better priority date, which is current than mine, which, my priority date is October 2019, and of course it'll take me forever. But fortunately, I'm able to use her country of chargeability as a leverage. And,
I just want you to explain that. Thank you for explaining it. Anybody who is born from a different country than India, please notify your lawyer immediately. One thing I would request you right now is that these kind of things are better to raise, to contact the Ombudsman's office, though, because technically there is a problem there. They may have considered you as an Indian national because you are born in India, your passport in India, your wife is born in Canada. It sometimes doesn't reflect in the records of them. Though at the time when you file a 485, they have taken your 485, they have already considered your wife, though, the system that they have sometimes gets confused. Some senior and nice officer should be able to do the cross-chargeability. The best thing for you is to contact the Ombudsman's office. You can Google Ombudsman, USCIS, and there is a case assistance. That is the best way, so that you should be considered under Canada and not under Indian quota.
Okay, understood.
Right.
Thank you.
Okay, I will do that right away and not wait for my call back. Thank you.
Sure.
Thank you, sir. Thank you so much for calling in.
And Nithya, a lot of people ask, my child is born in Canada, my child is born in this country. Am I eligible for the cross-country? No, it's only your spouse or
only
you
your spouse.
must be born. Yeah.
Rahul Garu, I'm just having this flash memory of, what the matrimonial columns are going to look like, after this information. And but who has to be, all of this plus
born in some other country.
Born in India at all. She has to be Indian in every way, but
India.
Not born in India. Thank you very much. All right, let's take our next caller, Andy, and I have a question for you, Rahul Garu. Can you put your phone line on mute for a minute, please? Thank you. All right. Let's see. This next question, sir, is from Nitin Soma. Says, my I-765 and 485 cases have been updated to fingerprints 20 days before documentarily complete, dates retrogressed. Any chance for GC approval before November dates will kick in. He's apparently getting multiple offers, documentarily complete. If I'm not getting my GC by end of October, can I activate my EAD with my current employer and share the EAD with multiple employers without needing to apply for a 485 Supplement J application?
If you are maintaining your current job and you're adding another job, though, practically you don't need to have any new employer to file the 485J supplement. If you are leaving your current job and then you're going to another job, I would strongly recommend, it's not an absolute necessary, I would strongly recommend to file a 485J supplement. Okay. The question is that he also asked a question, can I use the EAD to work for multiple employers? The answer is yes, you can.
Okay.
You will be considered to be married to this application if you use the EAD. We have defined the marriage. Nithya Garu has invented this word called marriage. So we have defined what marriage is. If you go back to the previous things, you will understand what a marriage of the. You'll be considered to be married if you use the EAD with multiple employers.
Right. Okay. Thank you, sir. Let's take our next caller, Andy. Caller with phone number ending in 5888. We're ready for you now.
Yeah. Hi, Rahul. Can you hear me?
We can hear you, sir. Please go ahead.
Hey, yeah. Quick question. With EAD, with the green card EAD, can I work like 2 jobs, like 40 hours at the same time? What are the implications of doing that?
Nothing. Your paycheck will be fatter. Your bank balance will be better. Your investments will be better. Your wife will treat you better. I guess so. Absolutely, you can do so. We on the EAD, why not?
Okay. Does that pose any risk at all?
No, absolutely none.
Not at all.
Can you go to the 485 interview and tell that you're working for 40 hours? The officer will feel jealous about it. Man, this guy is working. Makes $200,000. Nothing. Everything is good. Absolutely no problem with it. That's the whole reason why you file the 485 application. That's the reason why people say that, hey, why are you encouraging people to file the 485 when the final action date is not current? Well, there you go. H1B has too much complication. EAD, that's it. You just do EAD, you flash everywhere. It's a magic card anywhere you go.
Yeah, it's like a green card without the green card.
You have a problem with the money, Nitya Garu and I will be waiting for it, okay?
Yeah. We have Venmo and Zelle also, Andy, in case you feel like sending some money faster.
That's good. That's
right.
good. I see a lot of Nitya Garu, lot of people are working multiple jobs. IT profession is in high demand. That's good. These young guys and girls are working so hard and then making money, and why not? They should pay taxes. And they will be paying taxes. That's good.
Yes, sir. Thank you so much. Thank you, sir. Thank you for calling, Andy. Let's take our next caller. Rahul Garu, there was someone by named 𝗔𝗦𝗓𝗏𝗔𝗦𝗓𝗏 𝗧𝗘𝗟𝗨𝗚𝗏. Wow. Sorry, sir. I hope I didn't butcher your name. Is it necessary to be paid by the same employee who filed GC? The perm mentioned wage in employment-based EAD while using the EAD. Will it be any problem during the renewal of EAD if the wage is lower?
No, actually, when you renew the EAD, there's no question whether you are working, whether you are being employed, whether you're getting paycheck and all. Of course, they may be relevant to the 485. But as such, though, the wage doesn't have to be paid. It is a promise of the wage to be paid after you get the green card. It's not your current wage. So even if you are getting paid less, it's not an issue. You can still renew the EAD. You're fine.
Okay. Awesome, Andy. Thank you so much, folks. Stay tuned. Don't go anywhere. We'll be back after a quick commercial break.
Are your kids aiming for top Ivy League colleges? Are your kids aiming for top 1% scores in SAT or ACT? What is the biggest hurdle? English. To have a strong foundation in English, Test Prep Pundits presents long-term SAT, ACT English program with robust curriculum and experienced teachers for grades 6 through 10, just $80 a month. Contact us, info@testpreppundits.com, or call us 844-383-7844.
ఈ పండగ సీజన్ లో మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి గిఫ్ట్ ఆఫ్ గోల్డ్ తో ఇంట్లో సంతోషాలు సమృద్ధిగా నింపండి. బంగారు వజ్రాల ఆభరణాలపై బంగారు నాణ్యాలు గ్యారంటీగా పొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. చక్కటి డిజైన్లన్నీ చక్కటి బహుమతులతో సహా చక్కటి ధరలకి ఎంజాయ్ చేయండి. అపరిమితమైన సంతోషాలని మీ ఇంటికి తీసుకువెళ్ళండి. మలబార్ గోల్డ్ అండ్ డైమండ్స్, సెలబ్రేట్ ద బ్యూటీ ఆఫ్ లైఫ్.
సిలికాన్ ఆంధ్ర మనబడి అమెరికాలో ACS వాస్క్ గుర్తింపు పొందిన ఏకైక తెలుగు విద్యాలయం. మీ పిల్లలను 2021-2022 తరగతులలో చేర్పించండి. తరగతుల నమోదు ప్రారంభమైనది. సెప్టెంబర్ 11, 2021 నుండి తరగతులు ప్రారంభం. మనబడిలో చేర్పిద్దాం, తెలుగు భాష నేర్పిద్దాం. మరిన్ని వివరాలకు సంప్రదించండి manabadi.siliconandhra.org, info@manabadi.siliconandhra.org, 1844-626-BUDDY.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour, or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info@testpreppundits. Call at 844-383-7844.
తెలంగాణ అమెరికా తెలుగు సంఘం TTA ఆధ్వర్యంలో న్యూ జెర్సీలోని కన్వెన్షన్ అండ్ ఎక్స్పో సెంటర్ లో మే 27, 28, 29, 2022 ఈ 3 రోజులు మెగా కన్వెన్షన్ నిర్వహించనున్నారు. ప్రముఖ వ్యాఖ్యాత సుమా కనకాలతో పాటు మరెందరో సినీ రాజకీయ ప్రముఖులు విచ్చేయనున్నారు. అంతేకాదు ప్రముఖ గాయని గాయకులతో SPBకి ఘన నివాళి, కప్రిసియో బ్యాండ్ మరియు వైవిధ్యభరితమైన ప్రత్యేక కార్యక్రమాలు ఆహుతులను అలరించనున్నాయి. ఆటలు పాటలతో సినీ తారలు, బుల్లితెర నటీనటులు, జానపద కళాకారులు, అందరికీ ఇదే మా సాదర ఆహ్వానం. ఫర్ మోర్ డీటెయిల్స్ ప్లీజ్ విజిట్ www.tdaconvention.org.
A new wave in the test prep. Test prep pundits offer SAT, PSAT, ACT just for $499, with powerful teachers, with top 1 percentile tutors, and powered by stellar digital curriculum. Contact us at info@testpreppundits.com or call at 844-383-7844.
If tax rate is your issue, we're probably not your state.
Tone deaf and out of touch. Phil Murphy just doesn't get it. I'm 𝗔𝗦𝗓𝗨𝗚𝗨. It's not just taxes where he's failed us. Phil Murphy ignored the warnings and sent COVID patients into nursing homes. 8,000 seniors and veterans died. He tried to ban cops from notifying parents when kids are caught with drugs or alcohol. Who does that? Had enough? New Jersey, it doesn't have to be this way. We can do better. And when I'm governor, we will.
Fine diamond jewelry is now one click away. Maya Fine Jewels, a family legacy, manufacturing their own jewelry since 1975. Shop online for lab-certified diamond jewelry at Indian prices. Visit your trusted family jeweler, Maya Fine Jewels, at 1315 Oak Tree Road, Islin, New Jersey. Shop online at mayafinejewels.com.
All right, folks, welcome back. Let's start with our callers again. And Rahul Garu, while we're taking our next caller, Andy, I have a question for you. This is an interesting one too. This is from Ravish Rao. He says, can I work only part-time on my 485 EAD with me being the primary applicant?
No, I would not recommend that you work part-time. Please, if you are intending to, you should consult a lawyer. There are ways out. I don't want you to work part-time without consulting a lawyer.
Okay.
Since
Rahul,
you're the primary applicant. If you're a dependent, you can do whatever you want.
all right. Rahul Garu, before we go to our caller, Andy, I just wanted to touch base upon the budget bill. Can you let us know if you have any updates on the budget bill?
The budget reconciliation bill, Nithya Garu, is definitely in, there are a lot of things going on. It's stuck there. The immigration provisions, Plan A failed, Plan B failed, Plan C, they're working on it.
Right.
And if that fails, so they're thinking of issuing a parole for all the people who are present here on this 2010 or 2011. They haven't decided it yet on that, though.
Okay.
However, there is a recent development in Washington, D.C. The Democrats want the voter rights bill to be passed, but it was blocked in the Senate because of the filibuster rule, which is not there in the Constitution. But they put a rule by themselves that it must be passed with 60 votes majority. There are some technical things attached to what I said, but overall, 60 senators have to be there. The Democrats are upset with it, and they want to do away with the filibuster rule completely, which is very good. If that happens, though, then practically the parliamentarian is out. We don't need to worry about parliamentarian too, because then we can get our immigration bills also. So we'll have to see if the Democrats are going to move to get away with the filibuster. But at the time of the elections, though, they did indicate it very clearly that they are going to do away with the filibuster rule, because now they have the majority in the Senate. Now they have the majority in the House. And of course, President belongs to the Democrats. So they can do what they want, at least in the law-wise. So they may be doing some things. So we'll have to see in the next 1 to 2 months. There'll be a lot of developments in Washington, D.C. At this point of time, though, it doesn't look like the things of the employment-based are are going to be presented in the budget bill, though. They do have provisions for parole where people will be allowed to stay in United States and work in United States and probably be allowed to travel outside United States also. It doesn't look like the Democrats are insisting very much on getting other employment-based immigration, including the increasing the numbers, utilizing the unused green cards, and not counting the wife, filing the 485 application once the I-140 has been approved for more than 2 years. Most of these provisions were there in the House bill, but it doesn't look like the Senate bill will have those things. So that's the reason I urge all the people that we have given a link at the bottom to write to the congressman to get these things. But it doesn't look like they are getting included in there. The only thing is that those people who are present here in 2010 or 2011 most probably will get employment authorization, though. That's the one provision that looks to be happening now in the budget bill.
Okay. Thank you so much for that, Rahul Garu. I appreciate the updates. Let's take our next caller, Andy. Caller with the number ending in 9121. We're ready for you now. Caller with number ending in 9121. We're ready for you. Hello? All right. While we're waiting for this caller, let's take our next caller. And in the meantime, Rahul Garu, here's an interesting one. This is from, sorry, Andy, just give me 1 second. My screen kind of froze. Okay, this is from A. Kumar. He says, changed company last year, I-140 approved, priority date Jan 2016. New company perm is in progress. Moving to another position in current organization. Do I need to, do anything over? And also, the more interesting question is, are we just milking cows for the government? And should I give up on getting my green card? Again, priority date 2016.
Definitely, I do not want you to give up on the green card application yet, though definitely not year 2016. There are a lot of things that are moving there. We may expect the entire 290,000 green cards to be issued this year, hopefully so. If nothing in the law gets obstructed, the pace at which USCIS is going, they are going at a very faster pace. So that's a good thing about it. Are we the people who are milking? Let's say one thing. Any country you go, we definitely have to pay taxes, though. Even if you go to India, you have to pay taxes, though. The good thing here, a lot of people don't understand, Nitya, is that if you work for 10 years in United States, also called as 40 quarters, no matter where you are eligible for the Social Security at the right age. So if you are 64, it depends on 64 to 67, depending on what your date of birth is. So if you have contributed 10 years, you go to India, though, you will still get the Social Security.
Right.
Even if you don't have a green card, even if you don't have a citizenship, even if you don't even have the H4B, but you are staying in India, you contributed to the 40 thing, you are eligible. There's an article that I've written, if anybody wants to read it. It's there on rnlawgroup.com, and a lot of people tried it. That's the only article written on that particular issue because I've never seen any article. I've researched it, contacted the Social Security office, and people got the Social Security staying in India too right now.
Sir, this is something that we haven't really heard of at all. Like for me, also, this is a new piece of information that you do have.
I had a consultation, so somebody asked, why can't we get it? Yeah.
All right. Thank you, sir. Let's take our caller only. Caller with number ending in 6835. We're ready for you. Caller hello?
Can you hear?
Yes, sir. We can hear you. Please go ahead.
Hi, Rahul and Nitya. Thank you for taking my call. I have a question regarding the age scenario, Rahulji. So, thing is, my priority date is October 2014. With 2020 visa bulletin, I filed downgraded to EB3.
Of course.
We got EAD, and even I applied for my EAD renewal also last week. So question is, based on the events that are happening in employment-based immigration, my son, he's 11 years old. Is it wise to use the EAD or should I stick on to H1B? I know you say
I got your point. 11 years is 10 years from now, of course, before the kid becomes 21 though.
Right.
It's not that the people who are in adjustment of status, it's not that they cannot move to the student visa though. The only problem is that they cannot change the status while in United States once the kid gets married to the adjustment of status though. Since he has to go outside the country to get the stamping though. I'm not going to tell you what you should do, but I will tell you what I would do if I were you. If my son is 11 years old, my priority date is October or August of 2014, which there's a possibility that it may not become current soon. I will use the EAD. The only risk would be that at that point of time, when your son becomes 21, he has to go outside the country to get the stamping. That is the only minus point that you have.
Okay.
He will be facing a risk of getting the student visa or not. So I would definitely, I would do the EAD application. There is a slight element of risk for the kid to get the student visa to come back into the United States. A lot of people have said that once you file the 485 application, you cannot file the F1 application. We always discourage that is not true. We filed many people who are maintaining the H4 status, who filed the 485 application. We filed their F1. We had no problem in then getting the F1 visa though. Now, when it becomes to the consular processing, it definitely, there is a slight element of risk there since it's 10 years. Instead of maintaining the H1Bs, H4s, and so on and so forth, and kid not being allowed to work until he becomes eligible until he moves to F1 visa. I personally will move to the EAD if I were you.
Got it. So then the follow-up question. So if I'm married to EB3 EAD, in case EB2 line moves fast, can I interfile if I move back to my old employer?
Okay. If you move back to the old employer, you can. But if you are with a different employer, though, the new employer has to file a labor and I-140 for interfiling. Interfiling can only be done by the employer that has the I-140. So you're right. You may have to move back to the old employer or have a new employer file your I-140 application. Or if you're doing two jobs, then the employer that has the I-140 can do the interfiling for you.
Oh, even that's a part-time?
Let's say, for example, you're doing two jobs. One company has the I-140, one company doesn't have an I-140. The I-140 company can still do the interfiling, even though you're working for a different employer, even though you're married to that status.
Yeah, and even the 140 company, I'm doing a part-time job.
You could say, yeah, even they can do it too. Yes.
Got it. Okay. That's all. Thank you so much for your time.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller, guys. Rahul Garu, I have a question for you. This is from Sube. Sorry, Sube, we try to pick the questions as and when they come, but here's your turn. So it says, can we file an H1B extension after 6 years on it when priority date is current and 485 is pending?
If the final action date is current, though, you can still file, but you would be eligible for only for 1 year of H1B extension. There is a discretion where they could deny if they want to, but we haven't seen any denials yet, even if the final action date is current. You can still file a H1B. We have seen it, and we are only, but you're only eligible for 1 year H1B extension.
1 year. Okay. All right. But before we take our next caller, Rahul Garu, I just had like an observation, and it's more so about, we go through such, major hoops with the employment-based immigration. And at the end of the tunnel is the point where you can actually go and flip burgers. So I
didn't say burgers. You can be Microsoft CEO too.
No. I'm saying you have the option of doing that, which means that potentially every IT employee that comes in here can be a burger flipper, right? I was just, thinking of how ironic it is in the sense that, they make us go through so much hoops in terms of like our position, age, what hours we're working and this and that, only to end up at a spot where okay, now you can even flip burgers if you want to, it's kind of like a weird situation, I feel. But
it's a liberty feeling. It's a liberty feeling that you get when I say flip a burger or Microsoft CEO. Since we are the community that have to go to a lot of hula hoops, at the same time, an average Indian family's income is double that of the American nationals that are born here. And we are the persons who have more degrees. We are the persons who per capita income is much higher in the United States.
Right.
And that's probably because we're going through all these hula loops. So it has a plus point.
It has a plus point also. Okay. Thank you for that, Rahul Garu. Let's take our next caller, Andy. Caller with phone number ending in 2600. We're ready for you now.
Hi, Rahul Garu. This is Bose. Actually, my question is my priority date is Jan 3rd, 2013. And actually, my green card EB3 EAD got approved in March 2021. But we started using a derivative application EAD, not primary applicant, from September. But luckily, we got, after 1 month, we got approved our H4 and got our H4 EAD. My question is here, two questions. Is he on H4 status or EAD? And second question is is we eligible to apply I-485 in EB2 because the priority date is 2013 Jan 3rd. So because a derivative application started using a EAD, right? Can we? I don't know whether we are eligible to file 485 or not. But primary applicant is still using H1B. But that's my question.
There are many exceptions available for that general rule of marriage. The first and easy exception is that she can go to Mexico and fly back and show the H4 I-94, and then she will be considered to be an H4 then. And at that point of time, she can still file the 485 application if you intend to refile the entire 485 application. That's the number one exception. Number two exception is that if a person is not maintaining a legal status for a period of less than 180 days, they are still eligible for the adjustment of status. That's the second method of doing it. I would rather choose the first one because she still, cannot use the H4 EAD after she comes in. So the easiest method is let her fly to Mexico and come back. Now, the reason why Nitya Garu is invented the word marriage, there's when you're flirting with a girl is different. When you get married is a different issue. Is that extra process of going outside the country for her and coming back is that extra diverse process that is there. So yes, she can divorce this 485 application and come as a fresh bride. Okay?
Okay. And if not, I have option only to interfile, right? In that case.
That's right.
It's not flying out.
That is, you're absolutely right. You can interfile even though she has used the EAD. Absolutely you can.
Okay. Thank you very much, Rahul.
Thank you, sir.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. Rahul Garu, I have a question for you. This is from Ram W. Says, I'm on L1A, US citizen son petitioned for GC, I-130, 131, 765 approved, got an RFE for NABC. Lawyer replied stating it is not needed for those born before 1970. Now they're issuing NOID. What do I do?
Sorry, what are they issuing?
NOID.
I could get the last wording.
NOID.
Notice of intent to deny. He has his EAD application he has his EAD approval, is right? With the son filing the...
It says 130, 131 and 765 have been approved. I'm not sure.
That is, the EAD is approved.
Okay.
If his EAD is approved, if he is EAD approved, he can do this with his L1.
Oh gosh, okay. Sir, maybe don't do that.
He can throw it. Yeah, he can do it. He doesn't need anything. Absolutely. No matter what happens, he's fine. So he doesn't need L1s anymore. He has his EAD. he will be considered to be immediate citizen.
Okay.
Even if he may have violated the status, he is perfectly fine to get this.
So what are his next steps? Like,
even if he is illegally present, here from past 5 years, as long as his entry is legal, he comes under immediate relative. Absolutely, he can do this, and so is L1 is out. He doesn't need it.
Okay. What are his next steps, Sandy? Since they're issuing the NOID?
Nothing. Use the EAD. It doesn't matter. He can ignore it, withdraw it, ignore it, use the EAD. That's it.
Okay, perfect. Awesome, Andy. So, Ram Garu, if you're watching this, so well, congratulations, I guess. On to our next caller. Caller with number ending in 0369. We're ready for you now. Caller with number ending in 0369.
Yeah. Hello, Rahul and Nitya Garu. Hello, Andy.
Hello, sir. Hello, sir.
Yeah. This is regarding, I have my wife priority date Jan 2013, and I have, it's a straightforward application. She is the primary, and it's a green card is pending. Final action date is current since August, and we got the green card. There is no issues, no RFCs, everything is good. And my application, my I-140 is May 2011. I didn't apply it because the green card is pending, and it is recent November visa bulletin dates are going to be retrogressed, right? So we are so concerned on that. So my employer ready to apply I-1 485 again, but I'm confused. Like, should I apply for?
Your wife got the green card. Is that what you said?
No. She didn't got the green card. She is current. Final action date current since August.
Okay. So why didn't you file? Why did not you file along with her?
I filed already. It is on October 2020. I filed as a derivative applicant, and I got EAD.
I got it. Now the best thing. Are you still maintaining the non-immigrant status, both you and your wife?
Yes, both are in non-immigrant status, and my H1 is valid till 2024. And I have I-140 filed with current employer on February, and I did the premium on last week, so it will be coming premium. So my I-140, my priority date is EB2 2011 May. Right now it is current.
Of course it is. Yeah. The best thing for you to do is file the entire 485 application. You as a primary applicant, she as a derivative. Then
my employer is right now. I did the premium processing for I-140, but my question is, do I also file for EAD and for I-31 IC-765 also?
Yes, I would do it. It's free. It's coming free, because I would file it, and whether or not I would use it, it depends on later on though, but I would file it. Normally lawyers don't charge anything extra for it, and filing fees is free. I would file it.
Okay. So if I travel, I can use which EAD I can use? I have to use my wife EAD?
That part you can discuss later on though. That's a little bit extensive question. But right now, since the priority date is current, file the 485. Okay? And which EAD
and I will use it in the letter to the Congress. Yeah. For speed up. Only 7 days left for current this.
That is a very nice step that you're doing, sir. I'm proud of you. Thank you.
Thank you. So thank you so much for calling, Andy. Let's take our next caller. And Rahul Garu, I have a question for you. This is from Samuel Metu. Says, can I file my spouse's advance parole 131 after the priority date retrogresses, or is it better to file now? Adjustment of status was filed last October 2020. She received the EAD. USCIS lost the I-131 form, but the attorney did not care to file again.
There is, with regards to filing the EAD applications or the I-131 advanced parole applications, you do not have to worry about whether the priority date is current if the priority date is not current. If your 485 is pending, you are eligible to file the I-765, also called as EAD form. Also, you can file I-131, also called as advanced parole. It does not matter if the filing date is current, final action date is current. If it is backtracked, you are still eligible to file, you're still eligible to get the EAD, you're still eligible to get the advance book.
Gotcha. Thank you, sir. Let's take our next caller. Caller with a phone number ending in 5261. We're ready for you now.
Hello, can you hear me?
Yes, sir, we can hear you. Please go ahead.
Hi, thank you so much for all your great work. So I have a situation going on where we have two 485s applied. My wife's priority date is October 2011, and mine is September 2012. So she already got her green card on September 21st, but mine as a derivative was pending, and it got transferred to National Benefit Center just on 14th. So my question is basically:
Are you maintaining the non-immigrant status?
I am, yes.
Okay, go ahead. Keep going.
Yeah, so I have a non-immigrant status. I haven't used my EAD at all. So we did get our EAD and advance parole on both our applications. So each one of us had 2 EADs and 2 APs. So my question now is basically, like my options are, do I go ahead and file for a F2A in case there is still more delay? Although our October 2011 is still valid. There was another issue.
I will file F2A.
So I will go ahead and file an F2A. Okay. There seems to be a problem with my I-485 notice, though, that the priority date on my I-485 notice still has my priority date and not my wife's priority date. So do you think that could be one of the reasons why this has happened?
It's to remove all the doubts of that, though. I-485 have your priority date instead of your wife's. I want you to contact the Ombudsman's office. They may have got confused, though. Recently, we have noticed that for some people, though, one person is getting, another person is not getting, because we have a lot of these young officers or officers with no experience adjudicating the 485 application, though. They may have got confused. If you look into the amount of green cards that were approved in the last quarter of last year, though, they've approved more green cards than the first 3 quarters of the first 9 months, though. That could be the reason. But I would raise a request with USCIS Ombudsman, pointing out what you told me about the priority date that appeared on the I-485 and indicating that that could be the reason why you did not get the green card, your wife got the green card. But at the same time, I don't want to take any chances. I'll file an I-130 485 application for you.
And how long would that take? So I did raise the Ombudsman's request already. They came back saying that the case is within processing time.
Yeah,
although,
that's fine.
To my local field office.
Yeah, I got the point. Right. You did a good job in raising. How long does it take for if you file a 485 application again? It may take 2 years again, though. It may. But since you have 3 applications, you don't know which one will get approved. If your wife's is current, though, you can always get approved at any time. I-130 F2A is almost always correct, 98% of the time. So I would file an F2A and then try my luck in that one too. Thank you.
Okay, and USCIS is telling me that I should now look at my local field office's case processing time, which is actually current right now. It's outside normal processing time, but for some reason the way US still showing Nebraska.
Normally they have a leeway for 90 days time, though. If it says current still, the service request or when you contact the Ombudsman, they will still say that it's within the processing time. That's a normal way they do it. If it crosses 90 days, that's when they give you, they will say that it's out of the processing time.
Okay.
Thank you.
This is for derivative file separation more than 90 days.
That's right. Thank you then. Okay. Let's go to the next
question.
Thank
you so much.
Thank you, sir. Thank you so much for calling.
Nitegar, I want to point out, first caller said both 485s cannot be filed. So it is an example. Both 485 can be filed, and he's going to file another 485. Instead of interfiling, though, this is a better method of doing business because USCIS, when you have so many tickets, anything can get you the green card. So it's always good to go if you are eligible to do in multiple ways, it may be better to do it. And this guy has a good strategy of filing the family-based green card F2A. That's a better way of going.
Gotcha. Okay. Wow. Let's take our next caller, Randy. Sorry, we have a question. I was just getting a little confused reading it. So this is a question is from Sushil Rao, says, if 80,000 GC numbers can be recaptured, will it benefit EB2 or EB3? Will the EB2 dates move ahead rapidly, or will it be the EB3 dates?
It definitely benefits all categories, though. They will go into each percentage-wise. Typically, we have out of 140,000, we have 40,000 going to the EB1, 40,000 to EB2, 40,000 to EB3. So it will be distributed in the same percentage the 80,000 recapturing thing will. He's speaking about the bill, Nithya Garu, that may save the 80,000, but that will lose 150,000 for us.
Yes.
So overall, I'm not happy with that. But if they're recapturing, why can't they recapture the 250,000 green cards plus 80,000? And then I'm willing to give up this 150,000 green cards.
Right. Rahul, I know there's a lot of people who keep asking about the lawsuit against the Texas Center because, you know, everybody I think is like pretty frustrated with the
We tried many different ways. So
right.
what the courts are telling is that we don't have a discretion. The courts don't have an authority to command an officer, which is not a routine duty. He has a discretion to approve or deny the 485 application. So we haven't been successful. We have seen the case of 𝗔𝗦𝗓𝗓 versus USCIS in the California District Court. Things didn't came out now, but these lawsuits are helping to an extent because they made some changes. Some of the times when they have to file an affidavit, though, they're helping it, but not to the individuals that are filing. So practically, we end up getting, you know, some of the cases that we are filing, we are just ending up eating up the cost because we are unable to provide the benefit to the individual clients. Some of the cases that we are fighting we are fighting in many different ways in getting these things, but we are not being successful yet.
So is it because it's like the State Department or DOJ that, sorry, not DOJ, but State Department that's responsible for bringing in like changes to the rules?
So what we're telling is that why is that?
Rahul Garu, do you mind repeating that again, sir? For some reason we're losing your audio.
Telling that not have the authority to force the USCIS. Sorry about that. The district courts are telling that they don't have the authority to command the USCIS officer to adjudicate the application because they have a discretion to deny it, and that's where they're shying away.
Yes, but who does then?
The only one is the administration. Okay. That's a government. So we have to keep a political pressure. We have to keep a pressure on the ombudsman to force the USCIS to work, which they did a good job in the last quarter. If they go in the same pace that what they did in the last quarter, I'm sure, because they adjudicated 100,000 green cards, employment-based green cards, which they were doing only at a pace of 25,000 every quarter, though. But when it comes to the last quarter, they did 100,000. They go at the same pace. We definitely should be able to, we should be fine right now.
Okay. All right. Thank you, sir. Let's take our next caller, Andy. Caller with the phone number ending in 4529. We're ready for you now. Caller with phone number ending in 4529. Please press *6, Andy, to unmute your line. *6 to unmute your line.
Hi, Nithya. Can you hear me?
Yes, sir. We can hear you.
Can you hear me, Nithya?
Yeah.
Hi, Nithya. Hi, Rahul. Thank you for taking my call.
Sure, sir.
I got a kind of a twisted or a weird scenario I'm currently in, and I need your help actually. So I filed my EB3 downgrade last year. My priority date is August 30th, 2012, and my I-140 is approved, and I received, as a primary applicant, I received my EAD and advanced parole combo card in the month of September. Unfortunately, my wife had to travel to India on an emergency, family emergency, and she didn't get her EAD. So I'm in a situation where the EAD I received, I really cannot use it, because if I use it, then my wife would go into
she cannot come on H4. You're right.
Correct. Exactly. So my question is two questions actually. First one is, shall I wait until in order for me to use the EAD, shall I wait until my wife comes back on H4 and then probably try to expedite the 765 and 131 application? Or shall I take this as an opportunity and contact probably a congressman to expedite my 485s to see if they can even, entertain, this type of requests? What do you suggest?
Contacting the congressman may or may not help. It doesn't harm for sure. You can try it, but definitely I don't want you to use the EAD until your wife comes into the United States on H4. Also, we have noticed that even though she is not eligible for advanced parole when she is outside the country, I have seen them approving the advanced parole applications even if they are outside the country too. So you have all three possibilities, but definitely do not use the EAD until your wife is back in this country.
Sure. Can I ask one supplementary question to what you just answered? So even if they, let's say they, I go to a congressman or I raise an expedite request with USCIS and then they approve my wife's EAD and advanced parole, let's say even though she is out, abroad, would it, would it make, would there be an issue if she comes back on H4 and starts using the combo card? Will that cause any type of issue later on?
No, if she comes back on H4 and uses EAD, absolutely I don't see any trouble. But I don't want you to use the EAD until she comes here. That's one strict condition.
Absolutely. Okay. Thank you so much, Rahul and Nitya. I really appreciate your help.
Thank you, sir. We thank you for watching our show. Thank you so much. All right, folks, I know there's a ton of more questions that we need to address and a ton of more callers are waiting to talk to Rahul Garu, but unfortunately, we're all out of time today. But do not worry, we'll be back same time, same place next week on the same show. Rahul Garu, thank you so much, Andy, for being on the show and for so patiently answering everybody's questions. We really appreciate that, Andy.
Thank you very much, Nitya, for inviting me.
And until next week, take care and be good. Thank you.
Are your kids aiming for top Ivy League colleges? Are your kids aiming for top 1% scores in SAT or ACT? What is the biggest hurdle? English. To have a strong foundation in English, Test Prep Pundits presents long-term SAT, ACT English program with robust curriculum and experienced teachers. For grades 6 through 10, just $80 a month. Contact us, info@testpreppundits.com or call us 844-383-7844.
ఈ పండగ సీజన్ లో మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి గిఫ్ట్ ఆఫ్ గోల్డ్ తో ఇంట్లో సంతోషాలు సమృద్ధిగా నింపండి. బంగారు వజ్రాల ఆభరణాలపై బంగారు నాణ్యాలు గ్యారంటీగా పొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. చక్కటి డిజైన్లన్నీ చక్కటి బహుమతులతో సహా చక్కటి ధరలకి ఎంజాయ్ చేయండి. అపరిమితమైన సంతోషాలని మీ ఇంటికి తీసుకువెళ్ళండి. మలబార్ గోల్డ్ అండ్ డైమండ్స్, సెలబ్రేట్ ద బ్యూటీ ఆఫ్ లైఫ్.
సిలికాన్ ఆంధ్ర మనబడి అమెరికాలో ACS వాస్క్ గుర్తింపు పొందిన ఏకైక తెలుగు విద్యాలయం. మీ పిల్లలను 2021-2022 తరగతులలో చేర్పించండి. తరగతుల నమోదు ప్రారంభమైనది. సెప్టెంబర్ 11, 2021 నుండి తరగతులు ప్రారంభం. మనబడిలో చేర్పిద్దాం, తెలుగు భాష నేర్పిద్దాం. మరిన్ని వివరాలకు సంప్రదించండి manabadi.siliconandhra.org, info@manabadi.siliconandhra.org, 1-844-626-BUDDY.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour, or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info@testpreppundits. Call at 844-383-7844.
తెలంగాణ అమెరికా తెలుగు సంఘం టీటీఏ ఆధ్వర్యంలో న్యూ జెర్సీలోని కన్వెన్షన్ అండ్ ఎక్స్పో సెంటర్ లో మే 27, 28, 29, 2022 ఈ 3 రోజులు మెగా కన్వెన్షన్ నిర్వహించనున్నారు. ప్రముఖ వ్యాఖ్యాత సుమా కనకాలతో పాటు మరెందరో సినీ రాజకీయ ప్రముఖులు విచ్చేయనున్నారు. అంతేకాదు ప్రముఖ గాయని గాయకులతో ఎస్పీబీకి ఘన నివాళి, కప్రిసియో బ్యాండ్ మరియు వైవిధ్యభరితమైన ప్రత్యేక కార్యక్రమాలు ఆహుతులను అలరించనున్నాయి. ఆటలు పాటలతో సినీ తారలు, బుల్లితెర నటీనటులు, జానపద కళాకారులు అందరికీ ఇదే మా సాదర ఆహ్వానం. ఫర్ మోర్ డీటెయిల్స్ ప్లీజ్ విజిట్ www.tdaconvention.org.
If tax rate is your issue, we're probably not your state.
Tone deaf and out of touch. Phil Murphy just doesn't get it. I'm 𝗔𝗦𝗓𝗨𝗚𝗨. It's not just taxes where he's failed us. Phil Murphy ignored the warnings and sent COVID patients into nursing homes. 8,000 seniors and veterans died. He tried to ban cops from notifying parents when kids are caught with drugs or alcohol. Who does that? Had enough? New Jersey, it doesn't have to be this way. We can do better. And when I'm governor, we will.
A new wave in the test prep. Test prep pundits offer SAT, PSAT.